Hello and welcome to another episode of Simplifying the Law. As you may be aware, or if you are new to this program, this is an initiative by the Government of Guyana, executed through the Chambers of the Attorney General and Ministry of Legal Affairs, to discuss legislation that is being enacted and even legislation which may exist on the books already for the benefit of you, the viewers, and the citizens of Guyana, so that you are aware of the laws of the country and the provisions which they may contain, penalties within these laws, or generally just to be up to date with what laws are for your own benefit. Every week we go through a different piece of legislation and feature different persons from the Chambers of the Attorney General or varying agencies with the requisite knowledge and skills to go through the specific legislation which we are dealing with. Today with me I have Mr. Michael Monroe and Mr. Vishal Satram, both of them legal officers at the Ministry of Natural Resources, and they're here with me today to discuss a very new piece of legislation which was enacted just this year, the Petroleum Activities Act, and this replaces the 1986 Petroleum Act. It's a technical piece of legislation, very tedious, and requires some level of expertise to go through and to become knowledgeable of what the provisions are, or to help you to become knowledgeable of what the provisions are. So without further delay, I'm just going to get straight into it and ask these gentlemen to introduce themselves for us today. Michael.
Thank you, Richard. As you said, my name is Michael Monroe. I am a legal officer within the Ministry of Natural Resources Petroleum Management Program, or it's colloquially known as the Petroleum Department or Unit, and we're responsible for administering the government's regulatory oversight of the petroleum industry.
Right, and I'm Vishal Satram. I'm also a legal officer at the Ministry of Natural Resources, focused mainly on petroleum, and I've been there for about 3 years now.
Okay, so thank you both for joining me this morning. Perhaps it is best to start with the fundamentals of the legislation, and so if you could just give us a brief overview of the Petroleum Activities Act and what it covers or what it touches on.
All right, thank you, Richard. So as your viewers would be aware, Guyana is characterized as the petroleum producing nation, and in light of the numerous discoveries and numerous commercial interests that we have in Guyana's basin, the government thought it fit to enact an updated version of our petroleum regulatory legislation. This legislation repeals and replaces the 1986 Petroleum Act that governed the petroleum industry prior to its enactment. And essentially, this act seeks to modify and enhance the government's ability to regulate the petroleum industry. And it does so by catering for many provisions that seek to further the government's regulatory oversight and monitoring of the industry. It looks at petroleum exploration, petroleum production, petroleum decommissioning, petroleum transportation. It also caters for petroleum carbon storage, and it caters for a host of penalties and offenses. And it also caters for enhancing the government's safety hand over the petroleum industry.
Thank you. So that's a quite wide range in activities which the legislation covered. So if we could just give us a little insight into how the legislation was drafted and what went into preparing the legislation.
Well, in preparing the legislation, we looked at the petroleum activities that would be involved. and we followed largely the same format or model that these activities take place in. So we moved from exploration, where they search for the petroleum, they conduct certain activities looking for deposits of petroleum. Then if it is commercially viable, they move into development. There are certain activities which is related to this, including drilling, procuring a lot of equipment and materials. Then from that, they move into production. That is where they actually produce the petroleum and they can refine or sell. And afterwards, when production is finished, we move into decommissioning and abandonment, where they have to close off the facilities and then restore the environment.
So, and in drafting the legislation specifically, I could only imagine that there was wide consultation and precedents or models followed from international or other countries.
So
if we could just touch on this a little.
Yeah, that's a good point, Richard. Ideally, we don't operate in silos, or we don't operate in a vacuum. The ministry had the benefit of international consultants with much more extensive experience within the industry that assisted in guiding us in our thought processes in how we craft specific aspects of this act, specifically tailored for the Guyana context. So in the first instance, the ministry, in consultations with the international consultants, developed a first draft. And as you would appreciate, that was done in consultation with the AG's Chambers Parliamentary Council. So through that iterative process, we continued to refine the document until it reached a stage where we felt comfortable enough to solicit the views of the wider public. So the document was put out to the public for consultation, and we benefit from an enormous and a wide perspective of viewpoints relative to the initial draft that we disseminated. But most naturally, again, as we benefited from those viewpoints, we internalized and we assessed based on our experience, based on the advice that we got from our international consultants. We tailored it to suit the needs and the experiences that we had within the industry. So we had a very fulsome drafting process, I would say, and that the act that exists today is a manifestation of us considering those viewpoints, both internally as well as externally.
What were some of the countries that we looked at?
So, as I recall very vividly, the Attorney General in his parliamentary presentation recounted that we looked at various legislation. We looked at Trinidad's Petroleum Act. We looked at the petroleum legislation from the United States, from Norway, from Angola, from the United Kingdom. So we had from Ghana as well. So we had a wide array of insights to how these other countries treat with these areas. And then we internalize and process, taking into account our experiences, how we want to shape the industry going forward for the benefit of the Guyanese people.
And where necessary, we also made sure that what was legislated was applicable in Guyana, and it would help us and suit our particular circumstances.
Correct.
So the legislation is divided into parts and covers a number of areas, as both of you would have mentioned earlier. But what are some of the key areas that the legislation covers?
So I would in the first instance, the petroleum industry is divided into different value chains. There's the upstream that deals with the exploration, the production, the development and the production of petroleum. There's the midstream that deals with the transportation of the petroleum. And there's the downstream that deals with the refining of petroleum. So this act is essentially an upstream act with elements of midstream activity, which caters for the pipeline operations license. So some of the key areas within the context of an upstream legislation, naturally would be exploration. It would be what happens after you explore and you find a commercial or not commercial discovery. Then it moves to development, it moves to production, and as Satram earlier indicated, it moves to abandonment. Abandonment in the context of our Petroleum Act, I would say, is a remarkable new addition because the 1986 Act didn't specifically mention abandonment. Now, this Petroleum Activities Act has a particular section that clearly articulates the government or the legislator's requirement for licensees to deal with abandonment and how they deal with abandonment.
Right. And in this particular instance, with regards to the petroleum industry, abandonment doesn't mean just walking away. It includes decommissioning, which is safely removing the equipment if necessary, or abandoning them in place. And there are certain studies which have to be done prior to this activity.
Correct.
So, a part of the act speaks of the administration authority and the granting of license. And there are several types of license listed within the legislation. Different license with different things, I would imagine. So, if you could just elaborate a bit on the different types of license so viewers could be aware of what they are or how they could go about even applying for one.
Right. So there are two main types of license with regards to the activity, which is the petroleum exploration license. This license allows persons who hold it to conduct exploration activities, to search for petroleum. And if they don't have this license, it is actually an offense to search for petroleum without it. From that, you move on to production licenses. Once there's a discovery, and it's deemed to be commercial, an application has to be made for a production license. And there are certain documents which have to be submitted, for example, field development plans. After that is considered, a production license is granted, and this allows people to produce and sell actual petroleum products. You want to touch on the other?
In addition to that, the legislation is quite expansive, as the 1986 legislation catered for what I guess a modification of the petroleum exploration license, which it termed a petroleum prospecting license, and it catered for a petroleum production license. But this legislation goes a bit further. It caters now for a pipeline operations license. And as viewers would appreciate, in the context of what we dub the gas to energy project, there is the development of a pipeline that is coming from the FPSO and it's going on land to the Wales development area or zone. So this legislation is laying the statutory foundation for the midstream industry insofar as it caters for persons who will be developing and operating a pipeline to now obtain a pipeline license. And that license naturally would contain conditions relative to the safe and efficient operation of the license. There's also now the catering for a carbon storage license, and this, in the context of our low carbon development strategy, is quite forward thinking because it considers, in the context of upstream operations or the upstream sector, as I alluded to earlier, there is this new phenomenon of carbon sequestration, plugging the carbon back into the fields of that the licensees are exploring. So this legislation is quite forward thinking again because it lays the statutory foundation for the granting of a carbon storage license. So as I said, the Petroleum Activities Act drew inspiration from many jurisdictions and then it tailored it specific to our local context. And within the context of our broader low carbon development strategy, this is quite a forward-thinking feat.
Definitely. In what instances can these licenses be cancelled?
Well, as alluded to, the license would cater for certain provisions and it would cater for certain conditions that a licensee would have to comply with. And naturally, if you fail to comply with the provisions or the conditions within the license, it now places the minister or the regulatory authority to consider that person is in default, and then it empowers the minister now to cancel the license, because you don't want to grant a license to a person to carry on an activity. The person is cognizant of the conditions on which this activity must be carried on, and then for whatever reasons they fail to comply. So essentially, once you're in default, the minister has the ability to cancel the license. Cancellation, however, does not automatically occur. The Act caters for preemptive arrangements that the minister must engage and write the licensee, hey, you're in default, this is what I consider you to be in default with. And then that person now has an opportunity to respond or take corrective measures. And if they ultimately fail to do so, then the minister naturally would have the right to cancel the license.
Okay, so recently we've seen announcement of new discoveries made offshore, and I know we spoke of the exploration license and we spoke of the production license, but does the Act also take into account or provide mechanisms to cover what is to be done when discoveries are made?
Right. So yes, the law does cover that. During the exploration period, when a discovery is made, the licensee must inform the minister that they have made a discovery. After that, they must take steps to determine whether or not the discovery is capable of development, whether it is commercial or not. After making that decision, to make that decision, there are several activities that they will undertake. And after making that decision, they must inform the minister whether it is potentially commercial or potentially non-commercial. If it is potentially commercial, then they will make the application for a production license.
Okay, and so I'm going along the process.
Correct.
So after the oil is discovered now, drilling begins. So there is a question in relation to proper storage of oil and other potentially dangerous chemicals, because as drilling commences, of course, we would have to be dealing with such. So does the legislation address this question of storage?
Well, it would depend on the context, Richard, because the Act caters, because we're considering or we've expanded the Act to deal with pipeline operations license. Within that pipeline process, there will be storage of petroleum. So that license contemplates provisions that will deal with storage. But more broadly, if we're looking at the storage of oil or refined petroleum, then that person would naturally be subject to another government agency, which is the Guyana Energy Agency, because that is entering the realm of the downstream industry. You would recall that we said that this legislation is largely upstream and it has elements of the midstream. So storage of petroleum is usually a downstream industry with some element of midstream capabilities. So outside of that, if we're talking of storage within the downstream context, there's the Guyana Energy Agency, which there are legislation that deals with the storage of refined petroleum. And also, as you would appreciate, there is the Environmental Protection Agency, which a person would require an environmental permit to deal with certain hazardous chemicals. So, in short, the legislation in the context of storage of oil is only for the pipeline operation aspect. But more broadly, we already have existing legislation under the Guyana Energy Agency, under the Environmental Protection Agency.
And it does allow for some temporary storage prior to sale or removal
Correct.
from within the production area.
Correct.
So it cannot be done outside of the production area. Then it is caught by other legislation.
Correct.
But we've been using some terminology here, which I would just like to simplify for the viewer. So you've been speaking of upstream, midstream, and downstream specifically throughout. And so if I could just interject here to ask you, to explain for our viewers what these terms mean.
So, Richard, forgive us because this has perhaps been our everyday parlance. So the upstream industry is essentially dealing with the exploration for oil, the subsequent development for the subsequent discovered resources, and if that is commercial, then it goes to producing, and from the point of producing up to the wellhead where the oil is then either transported through pipeline or vessels come for it through via tankers to uplift at the floating the FPSO. Sorry, that the upstream industry ends at that point. Where the oil reaches the wellhead or the point for transportation, that is the upstream industry. The midstream industry is from that wellhead to the refining process. So you have the raw product, the raw petroleum. It is produced, it reaches the wellhead, that's the upstream industry. From the wellhead to the point of transforming this raw product to a
consumer product.
That is the midstream industry. And then the downstream industry is taking the raw product, internalizing it or refining it, and as Satram rightly said, transforming it into a consumable product, which would be gasoline, diesel, and petrochemicals, and
Okay. So, in addition to storage, we were speaking about storage, right? So in addition to proper storage, another frequently asked question or concern is in relation to safety and emergency response. And this has been in the press for quite some time. So I'm certain, given that this is such a broad-based legislation and it takes into account so many things, I'm sure the legislation provides for safety and emergency response. So if you could take us through this.
Yeah, so essentially the legislation, again, this is a forward-thinking aspect of the legislation in that it transformed what previously never existed. Now, within the context of the legislation, it mandates the licensee to develop safety management systems. And these systems require them to either eliminate risk or reduce it to a level as low as reasonably practicable. So, in order for them to do that, the onus is now upon them to identify the risks that they perceive that are likely to there to encounter within their petroleum operations. When they identify the risks, they then now have to communicate to the government through the safety management system how they intend to mitigate the risk based on the risk profile that they attach to the risk that they identify. And once they identify and they articulate to the government how they intend to mitigate these risks or eliminate it altogether, then subsequently that document is approved and they now have a mandate to implement that document. This is in the context of legislating, and it's called a goal-setting approach. It is no longer incumbent on the government to say you must and must not do this. It's not prescriptive. In contradistinction, it allows, now it places the onus on the person who is doing the activity to identify the risk, see how they intend to deal with the risk, and then follow through. Because you're the person, you have more intimate knowledge of the area which you're conducting these operations. So this particular aspect of our legislation is quite it's up there in the first world in terms of how safety is dealt with, and it places the onus now, the responsibility on the licensee. Outside of that, there are other provisions that deals with the safety and security of their infrastructure. It deals with them having risk and security measures for their personnel. So it's the legislation is quite expansive in this regard.
All right. One of the hot topics in Guyana since the announcement that we've struck oil is the issue of a oil refinery. And I don't mean issue in the sense that it's contentious or anything. I'm just saying an oil refinery being established here. So does the legislation make any provision in relation to this?
Not specifically, because as we have said before, this is mainly an upstream legislation. It regulates upstream activities with a little bit of midstream. Refining is squarely in the realm of downstream.
Correct.
So this will require its own set of permits, its own processes, which is outside of the current legislation. It would be captured more by the Guyana Energy Agency and the Environmental Protection Agency.
That's right.
Okay. And I know another hot topic has been royalties, and we've seen this in the press every day, and everybody wants to add their 2 cents. So let me hear now, from the persons who are actually involved, if what percentage of royalties can we expect from the Petroleum Activities Act?
Okay, so that's an excellent question, Richard. And our Petroleum Activities Act, as very distinct from the 1986 legislation, it now mandates that the licensee, the holder of a license, must pay a royalty. However, the legislation does not go so far to say what percentage the royalty would be, because within the legislative wisdom, they understand that you can't, within a statutory framework, predetermine a fixed amount of royalty. Royalty and the financial arrangement for any petroleum province is dependent on many variables for which the legislation can't be dynamic enough to capture as time progresses. So while it places the onus that there is a statutory requirement to pay royalty, it does not say what the royalty is. However, your viewers would appreciate that currently there was a license bid around, and the Act provides that any license may be granted either through competitive tender or direct negotiation. Now, we have opted to go competitive tender, and within that competitive tender process, we have stipulated what are some of the
royalty rates,
the qualification criteria, and what are some of the fiscal arrangements that the government will require these prospective licensees to comply with. And it is in that mechanism that we have indicated a 10% royalty for the upcoming bid rounds. So again, you would appreciate that this new act mandates a royalty, but it doesn't go so far to say what the royalty is, specifically because you cannot, in a statutory framework or at the level of a legislation, say 10% or 9%, or because any change to that, we would have to go back to Parliament.
Right.
And that does not make economical sense in that every time we want to assess our fiscal take within the petroleum industry, we have to go to Parliament to say, change this, change that, change that. So it allows the government some regulatory space to say, you must pay a royalty, but based on the assessment of the current global market, the competitiveness of the global market, government will assess how it wants to be competitive, and in so being competitive, set the appropriate royalty rate for which it will subsequently grant a license.
Right.
I would also like to note that we have produced a few model petroleum sharing agreements.
Correct.
And royalty rates are prescribed in them.
Correct.
Okay. And like you've mentioned throughout this program, I think the term forward thinking
Yes.
is appropriate to describe that mechanism there. So there's definitely a lot of provisions which require oversight within this legislation because, like for example, you mentioned that in terms of the oil producers bearing the onus on them to do certain activities. So who ensures that compliance with these provisions are certain?
Well, the power under the Act is vested in the Minister with responsibility for petroleum, which is currently the Minister of Natural Resources. So he will be responsible for ensuring compliance and for regulating the petroleum sector.
I know the legislation speaks of an authority as well.
Well, the authority is the minister, but the minister doesn't operate in a vacuum. He is supported by the Petroleum Management Program team, which includes myself and Mr. Satram, as well as other members of the team. He's also supported by the Guyana Geology and Mines Commission, which historically was the technical or is the technical regulator of the petroleum industry. So in the furtherance of his oversight of the industry, he has within his ministry the Petroleum Management Program, and he also has the Petroleum Division of the Guyana Geology and Mines Commission. However, that, again, the minister is an instrument of the government, and the government has other governmental agencies that also have a role to play within the monitoring of the petroleum industry. There's the Environmental Protection Agency, which deals with the environmental aspects. There's the National Bureau of Standards, which deals with the metering and the measuring of the petroleum. There's the Guyana Revenue Authority, which deals with the fiscal side of the petroleum industry. So in the main, it is the minister, but he is supported by his internal department, and he has external agency support through the government as well.
And further to that, built into the legislation, there is the power for him to delegate his authority to any other agency.
Correct.
Right. So that would dispel the myths that it's a one-man operation. What other important mechanisms have been put in place for monitoring petroleum activities?
Well, as I recounted, it's largely the minister and his team, but the legislation also caters for and is cognizant that there are other legislation that governs various aspects of the upstream petroleum value chain. So there is the Environmental Protection Agency. The legislation is cognizant of the need to comply with the Environmental Protection Agency. There's also the tax laws for which the Guyana Revenue Authority administers. And there's also the Guyana National Bureau of Standards, which deals with the fiscal metering, the metering aspect of petroleum. So the legislation understands the minister's role, but it also understands the role of the other government agencies which assist in wholesome monitoring of the petroleum sector.
Okay. With every law, there are always some offenses or penalties that you, for failing to comply with, you would have to pay a fine or you're sentenced to imprisonment or however.
Or a little bit of both.
Or a little bit of both, right? So, what are some of the offenses created by this Petroleum Activities Act or the penalties, for breach of the act?
Yeah, so essentially the act it lays down the requirements that a licensee must comply with. And at the very least, if you fail to comply with those provisions of the Act, there is a fine attached to that. There is also the need for the licensees to submit certain documents to the minister. Now, the submission of these documents, as you would imagine, would inform the minister to exercise any power that is bestowed upon the minister by virtue of the Act. So if that person submits false information, or that person misleads the minister in any way, or fails to comply with any requirement, that too is an offense for which the person is subject to a fine. There is also the onus for certain aspects or certain types of information to be kept confidential. Now, if somebody, for whatever reason, decides that this information is no longer under the cloth, is no longer clothed by confidentiality, and decides to disclose that information, then that person is subject to a fine or a penalty. So the Act caters for what needs to be done, and failing to so do would expose that person to a penalty in the form of a fine.
Okay.
And there is also, I remember you asked the question earlier about cancellation of the license. For certain breaches of the Act, the license may also be cancelled in addition to the fines and fees.
Correct.
Okay. So I think all in all, the Act takes into consideration a wide range of activities, and it also provides the safeguards necessary to secure compliance with the legislation. So as we dawn the end of this program, I would just give you both the opportunity here to share your final thoughts, or anything that we would have missed, or I would have missed during our discussions. I just give you that opportunity now.
Well, I would just thank you, Richard. I'd just like to say that this Act is definitely an update and an upgrade from what obtained prior. It is more modern, and as Michael said, forward thinking. It is also tailored to suit Guyana's circumstances as best as possible at this time. But over time, it will evolve, it will change, and it will try to keep up in every way with the industry and how that moves forward.
Yeah, so I think Satram wrapped it up quite suitably. The Act is an enhancement to what previously existed. As you would imagine, the 1986 Act was enacted at a time that is fundamentally different from 2023. So legislation ideally is supposed to be kept abreast with the time for which it exists. It's at the end of it all, legislation, as I think some philosopher that I can't recall right now, it's an instrument of social engineering. And in this context, it's an instrument that seeks to engineer how the petroleum industry is operating. And it does so in a very forward-thinking way. It does so mindful of Guyana's development trajectory. It does so in a way that takes into account our local context and our specific needs, and it is nimble enough to allow us to traverse the industry. For example, in the context of the royalties, we don't now have to go back to Parliament every year if we have a bid round to say what the royalty is. It allows us, we know at carte blanche that you have to pay a royalty, but it allows the flexibility in terms of when you're going to a bid round, you assess the local or global industry, you determine how you want to be competitive, and you set that rate. So that is just a demonstration of how the Act is forward-thinking, but yet at the same time nimble, and giving us some flexibility to cater for the dynamism of the petroleum industry.
All right. Well, thank you both for coming here today and being on the program. And I think we've had quite fruitful engagement. And I've definitely learned a lot about the Petroleum Activities Act. So thank you for joining me today as our viewers would know, this is a program by the government of Guyana to educate and enlighten the citizenry on laws that are being enacted or legislation which may exist already, just to ensure that persons are up to date and kept abreast, specifically with the provisions of the laws, but more so penalties or fines which may exist, because, you know, as our Attorney General says, ignorance of the law is no excuse. So they have put together this initiative here, the government, to ensure everyone is aware and knowledgeable of, you know, what is going on in the legal sector in the country. Until next time, I am your host, Richard Bainey. Thank you for joining us.